So we need to talk about two Supreme Court decisions which actually impact your right to prevent search and seizure of firearms within your home. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is First Form. Check out First Form using the link down below. You can get supplements and all of that. And then also they do a fitness challenge every single year. And I believe the grand prize, if someone wins the challenge, is $75,000. So you can check that out as well. Again, link down below in the details section and in the pinned comment. As I mentioned in the intro, in this video, we're going to be discussing two Supreme Court cases, one which was a unanimous decision involving the warrantless search and seizure of firearms within a home, and the other one deals with an exception, the community caretaking exception, and essentially police officers not only holding an individual almost indefinitely, but then threatening to keep his firearms forever. The cases we're going to be talking about in this video are Caniglia versus Strom, and then also Tevia versus Suffolk County. These two Supreme Court decisions and cases come into play because they involve your ability to protect your firearms within your home and when law enforcement can actually enter your home and confiscate firearms without a warrant. Now, the facts surrounding the Tevia case are very interesting. Wayne Tevia is a 57-year-old man with no record of violence, no history of suicide attempts, depression, mental health, or any other issues. Early in the morning on April 6, 2014, his teenage granddaughter called social services, complaining that her grandfather was yelling at her and was acting irrational. Now, at no point did she mention a firearm at all during this call. And ultimately, following this call, to the social services, that social service department then called the Suffolk County Police Department, who then sent three police officers to the home of Mr. Tevia. When the police officers arrived at his home, they all agreed that nothing was wrong. There was really no reason for the granddaughter to make the complaints, that maybe the complaints were false. However, there was an incident that happened, which is very strange. At one point during the discussion between Mr. Tevia and one of the officer turned slightly and accidentally knocked down a magnetic drape that was attached to the front door. So a lot of people, maybe you have these magnetic drapes, in your front door, maybe for insects and other things like that. Well, the police officer knocked one of those down. Mr. Tevia then bent down to pick up that drape, and the officer then screamed at Mr. Tevia very loudly and told him to get back, and if he did not, he would be tased. Now, in response to that, Mr. Tevia claims that he said, "Please don't tase me, I could die, I have a heart condition." But the police officer, according to the report, alleges that he heard Mr. Tevia actually say that he wanted to be tased and that he wanted to die. And as a result of that, Mr. Tevia was arrested and then placed on psychiatric hold. Now, after dropping him off for the psych evaluation, one of the officers learned through a computer check that Mr. Tevia actually had a New York State pistol license and that he also had firearms within his home. The police officer then contacted his sergeant, who then instructed him to ask Mrs. Tevia to actually give up the guns and, if unsuccessful, to essentially threaten to keep Mr. Tevia on hold at the hospital. Now, eventually, the psych evaluation came back clear 12 hours later, and Mr. Tevia was actually recommended to be discharged by the mental health institution. However, the social worker also found out that there were guns at issue, that there were guns in the home, and then the social workers decided to once again call Mrs. Tevia and ask her to give up the firearms, to allow the confiscation of the firearms by the police department. And if they did not give up those firearms, her husband would not be released until they were given up. Now, under threat of being in indefinite hold and not being released unless he gave up his firearms, eventually Mr. Tevia agreed to allow the police department to confiscate those firearms. It then took Mr. Tevia 2 years to have his rifles returned, but he never got back his handguns. In fact, the police used the incident to revoke his handgun license. So those are the basic facts surrounding this case. This issue then spiraled from a baseless call from a teenage granddaughter all the way to him being held in a mental health facility and then threatened not to ever be released unless he gave up his firearms. Now, this case eventually made its way all the way to the Second Circuit Court of Appeals, and on review, the Second Circuit found that the police could do this under the special needs exception to the warrant requirement. In reaching that ruling, the Second Circuit largely ignored what the Supreme Court had recently said in a unanimous decision in a case called Caniglia versus Strom. Now, if you're not aware of what the Supreme Court said in the Caniglia case is a unanimous ruling, and that case dealt with whether the community caretaking exception to the Fourth Amendment actually applies beyond vehicles and actually extends to the warrantless search and seizure of firearms within a home. Now, relevant for both of these cases, back in 1973, the Supreme Court decided a case called Katie versus Dombrowski. In that case, the Supreme Court held that police officers had not violated the 14th Amendment by searching without a warrant the trunk of a car that was towed after an accident because it was part of the officer's community caretaking functions. The court found that the warrantless search of an automobile under those circumstances could be constitutional. However, in the Caniglia case, the First Circuit Court of Appeals held that the community caretaking exception to the warrant requirement could also apply beyond vehicles and could apply to your home. The Caniglia case made its way all the way to the Supreme Court, and the Supreme Court issued a unanimous decision in favor of Mr. Caniglia. Justice Thomas, writing for the majority in the opinion, stated that what is reasonable for vehicles is different from what is reasonable for homes. Katie acknowledged as much, and the court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit warrantless entry into the home. Based on that, the Supreme Court unanimously found that the warrantless entry into his home and ultimately the seizure of his firearms was in fact unconstitutional. Now, going back to the Tevia case, which came after the Caniglia case, the petitioners asked for the Supreme Court to reverse what the Second Circuit said because the Second Circuit outright refused to look at Caniglia. Now, the government argued that Caniglia was not applying in this case Tevia because Caniglia dealt with the community caretaking exception. However, the Tevia case, they argued, dealt with the special needs exception to the warrant requirement. The special needs to the warrant requirement has been recognized by the Supreme Court in limited scenarios. These include searches, conducted by Border Patrol, searches conducted in prisons, airports, student and employee drug tests, and other special types of searches and seizures. What all of these have in common is that each instance the court found that the suspicionless search rule at issue served some sort of special need, which was distinct from normal law enforcement needs. So it's outside of just traditional law enforcement conduct, arrests and investigations. It is something different. The type of searches that you go under during airport screening and all of that is different from traditional law enforcement functions. So the argument by the government in the Tevia case was that the special needs exception and the community caretaking exception are too far apart for Caniglia and that Supreme Court decision to actually apply in this case. Therefore, they argued that the Supreme Court should not review the Tevia case at all. And ultimately, the Supreme Court agreed with the government not only that the summary reversal was improper, but that review should not be granted. Therefore, they issued an order denying cert in the Tevia case. Whether that is because they believed Caniglia did not apply to this case and this specific situation, or because the petitioner did not properly plead the issue of an unlawful entry into his home, we really don't know, but the Supreme Court ultimately denied review in the Tevia case. So unfortunately, now some states have the ability to point at the Tevia case and the special needs exception as a potential lawful way that they can, go within a home, go to a home, seize firearms, and that's all done under the special needs exception. Now, in contrast, in the Caniglia case, after the Supreme Court's unanimous order striking down the whole community caretaking exception and extending it beyond vehicles into your home, the parties ended up actually settled that case, reached an agreement, reached the payment, I believe, of like $31,000 in damages to Mr. Caniglia, and then also, attorney's fees and all of that were paid. So there was a settlement agreement after that Supreme Court decision. Now, these cases are important because they deal with your protection against the search and seizure of firearms within your home without a warrant. That's very important because these all fall within the warrant exception. When was a warrant not required? When did law enforcement enter a home and seize firearms without a warrant? Some of these situations the Supreme Court said are unlawful, but when it came to the Tevia case, the Supreme Court declined to actually address that. And so under the Tevia case, it still stands as something lawful. And these are the type of actions that you heard Kamala Harris advocating more for. And so I think what's going to happen now with the transition of the Trump administration is, since we are going to have a broader, better federal and Second Amendment policy, you're going to see more liberal states like California, some of the new ones like Oregon, Washington, Illinois, New York, all of them are going to move more aggressively with their red flag laws and also trying to go within homes, search and seize without warrants, and confiscate more firearms. They're going to try to use this precedent more and more to actually confiscate those firearms. So these are two critical Supreme Court cases and issues that I think all gun owners should know because of the rise of these types of activities by law enforcement and state entities. So I hope you guys found that information helpful. If you have any questions, go ahead and comment down below and I will try to answer to the best of my ability. But as always, thank you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.